Hello everybody, I am Varunesh Renganathan, an intern at ubAdvocate, here to present you a video on Armed Forces Special Powers Act of 1958. Let's discuss why this topic has been in the news. The Nagaland Cabinet on December 2021 recommended the Armed Forces Special Powers Act 1958 be repealed from the state after the incident in Mon district in which security forces gunned down 13 civilians. The Armed Forces Special Powers Act of 1958 has been a controversial act over the years and has been criticized by various sections of the society since its enactment. This act gives unfettered powers to people deployed in armies to shoot and kill any person if they have any doubt that the person is a threat in any manner. This law has been and still continues to be misused by the armed forces, which is a sheer violation of Article 21 of the Indian Constitution. The law enacted even gives immunity or protection to the armed personnel against any type of prosecution. The AFSPA has been a topic of debate since its inception, and it should be struck down because it is misused by the people to a great extent. Let's understand the history of Armed Forces Special Powers Act. The Armed Forces Special Powers Act 1958 had its roots in the Lord Lincolntown Ordinance of 1942, which was enacted to curtail the Quit India movement by the Indian Home Revolution. After this, the government enforced this same ordinance as Armed Forces Special Powers Act, which was a law that was used back then by the Britishers to curb the movement of struggle for freedom, because of which many Indians were killed, imprisoned, and many families were destroyed. Once an area has been designated as a disturbed area, this act provides the armed forces with the following special powers: to open fire or use force, even causing death, against any person in contravention to the law for the time being or carrying arms and ammunition; to arrest any person without a warrant on the basis of reasonable suspicion that they have committed or are about to commit a cognizable offense; to enter and search any premises without warrant; to destroy fortified positions, shelters, structures used as hideouts, training camps, or as a place from which attacks are or likely to be launched. The Supreme Court, in its decision in the case of Naga People's Movement of Human Rights versus Union of India, upheld the constitutional validity of the AFSPA and laid down certain guidelines on how the act should be used. The do's and don'ts are a range of duties and responsibilities, such as a person should not be detained for more than the period what is required, he should be handed over to the nearest police station, and only force should be used when the person tries to escape, and no third degree torture should be used on the person or make the person confess for the crimes, and only the armed personnel are allowed to arrest the person. Also, the jurisprudence has been changed on fundamental rights given to us. With the judgment of Justice Retired K.S. Puttasamy and another versus Union of India, Article 21 has been inculcating multiple rights such as right to privacy. One of the another most important cases is in the case of Extrajudicial Execution Victim Families Association versus Union of India. It was a writ petition which had the number 129 which was filed in 2012. In which the court had laid down guidelines regarding the inquiry to be conducted for the fake encounters in the state of Manipur. And the Supreme Court held that the decisions taken by the Manipur police in exercise of force on the people are not permissible even in the areas which were declared to be a disturbed region and which was under the Armed Forces Security Act in the state of Manipur. The Supreme Court also given directions were given to conduct an inquiry regarding the encounters resulting in the deaths of persons, which was carried out by the police of Manipur and by the armed personnel deployed in Manipur. The Apex Court ruled that the Act cannot be said to provide blanket immunity to army personnel amidst anti-insurgency missions, and even in an area designated as a disturbed area, the forces can only utilize their special powers against targets that meet the criteria specified in the Act. The Supreme Court held that if any death was unjustified, there is no blanket immunity available to the perpetrator of the offence. The benches of Justice Madan B. Lokur and U. Lalit held, adding that no one can act with impunity, particularly when there is a loss of an innocent life. The Supreme Court added this point. If members of our armed forces are deployed and employed to kill citizens of our own country on the mere allegation or suspicion that they are enemy, not only the rule of law, but our democracy would be in grave danger. This decision was given in spite of the fact of Section 6 of the Armed Forces Special Powers Act of 1958. The courts gave this decision because they had to inquire whether there was an abuse of power by the people in the armed forces or not. This is not the first instance where the courts have taken such a decision, because it was already taken earlier in the Naga People's Movement for Human Rights vs. Union of India, which is a 1998 case with having the citation of 2 SCC 109. In another famous case of Indrajit Barua versus the state of Assam and another, an All India Reporter 1983 case, Delhi 513, where the court found and declared that it is the duty of the state to assure the protection of its citizens and the rights guaranteed under Article 21. In the case of Litkwa vs. Rishan Keshi, a 1982 case in Guwahati High Court, where a writ of habeas corpus was filed and the court ordered that the army should follow the rule of Code of Criminal Procedure, but there was an enforcement and nobody paid attention to the sayings of the Guwahati High Court. In return, the army officials have accused the judges of the High Court for weakening the powers of the military forces deployed in northeastern part of the country. Not only courts, but even governments have filed committees and centers for looking at Armed Forces Special Powers Act. One of the most important committee was the Justice Jeevan Reddy Committee, which was set up by Dr. Manmohan Singh, a former Prime Minister, which formally agreed to review the Armed Forces Special Powers Act after the killing of Tangjam Manorama Devi in the year of 2004. The committee, which was headed by retired Justice Jeevan Reddy, had, as it said, to review the Armed Forces Special Powers Act of 1958. It was set up whether it should be replaced with a more humane act, while taking into account the duty of the government to protect the basic human rights guaranteed to the citizens. When the report was submitted to the Home Ministry on 6th June 2005, the report even recommended that some of the provisions should be transferred to Unlawful Activities Prevention Act of 1967, and it also showed that it was a bad act. And now, when it has been enforced in so many parts of the country, it has turned into a tool of discrimination and violence. The committee also has to set up an independent cell, which would be called as the grievance cell, that will do the work to inquire into complaints filed for violation of basic human rights. Not only this, but the Committee of Justice Verma Commission in the year of 2013 has also reported that there has been abuse of powers by the armed forces. Other reports show that killing of Tangjam Manorama Devi by the Assam Rifles in the year of 2004 was not disclosed by the government. India is often considered as a country around the world that gives significance to rights and liberties of the citizens. In the wake of instances of fake encounters, extrajudicial killings, and massacres, the United Nations has taken into note the draconian law in 2012 and noted that Armed Forces Special Powers Act had no role to play in a democracy. The army fights high-intensity conflicts, and hence it is important to garner support from the people of the region to fight terrorism and insurgent activities. The armed forces must build the necessary trust among the locals and to ensure their support in countering insurgents. We all love our armed forces and we are proud of them, but when they make mistakes, we, as citizens of a proud democratic country, should stand up and ask questions. The government should consider the imposition and lifting of AFSPA on a case-by-case basis and limits its application only to a few disturbing districts instead of applying it to the whole state. The government and the security forces should also abide by the guidelines set out by the Supreme Court, Justice Jeevan Reddy Commission and the National Human Rights Commission. Thank you.